Hi guys, and welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we continue with the series on negotiable instruments, and we'll be talking about enforcement of the negotiable instrument. Specifically, we'll be talking about acceptance, in case of presentment for acceptance, and presentment for payment, as well as the effects after, which happen after presentment for payment. Okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Shout out, by the way, to Franco and his podcast and YouTube channel, Coach Franco Says. I recently guested on one of his episodes, and feel free to check that out. I'll link the episode as well as his channel in the description below. Okay? Now let's begin, In the last episode, I already talked about presentment for acceptance and how this will only apply to bills of exchange, They apply to bills of exchange. Presentment for acceptance rather applies to a bill of exchange because there is a party who will accept that instrument, namely the drawee, in order for it to be satisfied or paid later on. Okay, so there is an intermediate step when it comes to bills of exchange, namely presentment for acceptance before there will be presentment for payment. Then it will be either refused or discharged after, In case of promissory notes, there is no presentment for acceptance. So the rules on presentment for acceptance as well as acceptance itself will only apply to bills of exchange. Okay? So, last time I talked about presentment for acceptance, then if acceptance was refused or could not be obtained, and the result was dishonor. And the holder should give notice of dishonor to the party secondarily liable. Okay? But today we will talk about acceptance. In other words, if the bill of exchange was accepted, then the next step is to present it for payment. Okay, you have to present the bill of exchange for payment. Now, it can happen on different times. So, meaning, if the bill says it is payable at a certain date, you present it for acceptance on a certain date, then you present for payment on that date after. Or, where acceptance is necessary to fix the date of maturity, like 30 days from acceptance, You present it for acceptance, then wait 30 days, then you present it for payment. Okay? So, if there is acceptance, please remember, presentment for payment is still required. Okay? And if payment is refused, there is a need to give a notice of dishonor for non-payment. Okay, you have to give it to the party secondarily liable, otherwise they shall be discharged. Okay? Now, let's talk about acceptance. Okay? Acceptance is the signification by the drawee of his assent, to the order of the drawer. It is an act by which the drawee manifests his consent to comply with the request contained in the bill of exchange directed to him. Okay? He says now, I accept this and I will pay it when it is presented to me for payment. The object of acceptance is to bind the drawee. Remember, the drawee is not liable until he gives his acceptance and he becomes an acceptor. Now, the object again is to bind him and to make him a party liable on the instrument. Acceptance, of course, must be in writing and signed by the drawee. Okay, it can be stamped, stamped accepted. Okay, it can be simply written, as long as it is signed by the drawee. And it must not express that the drawee will perform his promise by any other means than by the payment of money. Okay, there should be no other act, only that he will pay money. Okay, now equivalent words to acceptance may be valid. Okay, it can be okay, as long as it signifies his assent to be bound on the instrument. Now, the holder, he may require that the acceptance be written on the bill of exchange itself, but if the drawee or the person to whom it is presented for acceptance refuses to write it on the bill or stamp it on the bill, then the holder may treat that bill as dishonored. Okay, and then we follow the procedure on dishonor that I talked about last episode, Now, acceptance can be a general acceptance, meaning that it is an assent without any qualification to the order of the drawer. Acceptance may also be qualified. Okay? And the qualified acceptance is that which in express terms, varies the effect of the bill as it is drawn. Okay? So the general rule is that the holder has the right to require the drawee to accept the bill without qualification. That's the general rule. Accept it as it is. If it is refused, then the holder may treat the bill as dishonored by non-acceptance. Okay? However, if he accepts the qualified acceptance, that is okay. Now, there are different kinds of qualified acceptance. We have the conditional acceptance, no? A conditional acceptance simply makes payment of the bill dependent upon the happening of a condition. For more on for a discussion on the conditions, just watch my episode on conditions and period in Oblicon, no? And my playlist on Oblicon. Okay? Now, the qualified acceptance may also be partial, meaning that the drawee only accepts not to pay for part of the amount on the bill. Okay? The qualified acceptance may also be local. Okay? Meaning he binds himself to pay only at a particular place. And finally, the acceptance may be qualified as to time. Okay? Meaning that the acceptance of one or more of the drawees, but not all of them, no? Meaning there is a certain time for each one of the drawees to accept. Okay? Now, what is the effect if there is a qualified acceptance? No? In other words, if there is a qualified acceptance, the drawer and the endorsers, meaning the party secondarily liable, will be discharged. Okay? Unless, in other words, these are the exceptions. No? Unless it is expressly or impliedly authorized, they have expressly or impliedly authorized the holder to take a qualified acceptance. Express or implied. Second, no? If they have subsequently assented to the qualified acceptance. In that case, they will not be discharged and they will still be liable on the bill and the qualified acceptance. Okay? So when the drawer or endorser, no, receives a notice of qualified acceptance, he must, within a reasonable time, express his dissent. Okay? He must say, no, I object, no, I do not want that qualified acceptance. Because if he does not dissent, then he will be deemed to have assented to the qualifying of the acceptance. Okay? And a subsequent party who causes the dishonor for a negotiable instrument through its qualified endorsement cannot hold prior endorsers liable on such instrument. Okay? Now, the holder may refuse a qualified acceptance, as I said earlier, and treat the instrument as dishonored, okay? And in which case, he has to notify or give a notice of dishonor to the drawer or endorsers. Because, why? The reason is, these secondary parties, no, the drawer or endorsers, they engage that the bill will be paid as it is drawn or endorsed, okay? And if there is a qualified acceptance by the drawee, no, then he will be modifying their contract. No, he is making a contract for them that they did not agree to when they first signed. Okay, so that is the reason. Okay. So if the holder accepts a qualified acceptance, he has to give a notice of that qualification. He has to inform the drawer or endorsers so that they will not be discharged if they give their consent. Okay? He has to tell them, hey, your contract is being qualified by the acceptance of this drawee. Do you assent to this or not? If they object, then they object. If they do not, if they expressly agree, then they will be bound on the instrument. Okay? Let's move on. Acceptance may also be constructive. Okay? Constructive acceptance happens if after 24 hours, the drawee fails to return the bill. If after 24 hours from presentment for acceptance, if after 24 hours from presentment for acceptance, the drawee fails to return the bill, or in case he willfully destroys the bill, then the bill is deemed to be accepted. Okay? Next kind of acceptance, we have the extrinsic acceptance. Okay? So, acceptance generally should be on the instrument itself, okay? As I said earlier. But if acceptance is written on a paper other than the bill itself, in order to bind the acceptor, the acceptance on the separate paper must be shown to the person to whom the instrument is negotiated. Okay, and such person must take the bill for value on the faith of such acceptance. In other words, okay, I'm accepting this bill because of the separate acceptance. Okay, so he has to be informed of that acceptance on a separate paper. Okay, and finally, we have what is known as the virtual acceptance. Okay, and it is simply an acceptance on a bill that has not yet been drawn. Okay, it's an unconditional promise in writing to accept a bill before it is drawn. Okay, and in such case, it is deemed an actual acceptance in favor of every person who, upon the faith thereof, receives the bill for value. Okay, so if the bill is accepted, the bill must now be presented for payment. Okay, the following rules on presentment for payment will now also apply to promissory notes. Remember, the only difference in our discussions recently is that a bill of exchange has to be presented for acceptance before it is presented for payment. In a promissory note, diretso na, presentment for payment na. Okay, there is no one kasi who will accept it pa. Okay, diretso ka na dun sa party primarily liable, the maker. Okay, so if the bill is accepted, then it must be presented for payment, or in case of a promissory note, it must now be presented for payment. And what is presentment for payment? It is the presentation of the instrument to the person primarily liable for the purpose of demanding and receiving payment. Okay, who are the persons primarily liable? In case of a promissory note, it's the maker. In case of bill of exchange, it is the acceptor, meaning the drawee when he has accepted the instrument. Okay, now presentment for payment is more than a mere demand. Okay, it requires a face-to-face interaction. Cannot be over the phone. Why? Because the bill must, or the instrument must be exhibited. It must be actually presented. Okay, I will let you know why in a bit. But first, presentment for payment consists of a personal demand for payment at the proper place, okay, and a readiness to exhibit the instrument if required, and to receive payment while surrendering the instrument if the person to whom the instrument is presented is willing to pay. Okay, now I'll give you the rules. If the instrument is not payable on demand, meaning it's payable at a fixed or determinable future time, then presentment must be made on the day that it falls due. Okay, it must be made on the day that it falls due. Okay, if not, then the secondary parties or the party secondarily liable will be discharged. And how do we count the days? We follow the rule that is applicable in law, in general. You exclude the first day and include the last day, So in case it says 7 days or 1 week from June 17, then you count from 18, 19, 20, 21, 22, 23, 24. You include the 24. You do not include the 17. Okay? So, you exclude the first day and include the last day. If the last day falls on a Saturday, a Sunday, or a holiday, then you make presentment for payment on the next business day. Okay, so if it falls on a Saturday, Sunday, or holiday. Okay, now just take note that if the instrument is payable on demand, it may be presented for payment on a Saturday before 12 noon, unless of course that Saturday is a holiday. Okay, now what if the instrument is instead payable on demand? Okay, first, if it is a promissory note, it should be presented for payment within a reasonable time after its issue. Okay, and for a bill of exchange, presentment for payment will be sufficient if it is made within a reasonable time after the last negotiation, promissory note from its issue, bill of exchange after the last negotiation. Okay? And what is a reasonable time? I've been mentioning this in the previous episodes. It depends on the nature of the instrument, the usage of trade or business, and the circumstances of the case. Okay? Now, in order for presentment for payment to be sufficient, no, it should be made by the holder or any person authorized to receive payment on his behalf. It should be made at a reasonable hour on a business day. It should be made at the proper place. It should be made to the person primarily liable, or if he is absent or inaccessible, then to any person found at the place where presentment is to be made. Okay? So the general rule is that presentment for payment is not necessary to charge the parties who are primarily liable. It's not necessary because they're absolutely liable. They have to pay in all cases, no? The maker is absolutely liable. The acceptor is already absolutely liable because he accepted. Take note, drawee is not liable yet until he accepts. Okay? So, it's presentment for payment is not necessary to charge the parties primarily liable since their liability is absolute. The holder can sue them even without demand as long as and after the instrument has matured and has not been paid. Okay? So, presentment for payment, just like presentment for acceptance, is necessary to charge the parties who are secondarily liable. Okay? So, if presentment for payment has been refused, same as with presentment for acceptance, it has been refused, you have to give the notice of dishonor to the party secondarily liable, meaning the drawer or the endorsers, as the case may be, to hold them liable on the instrument. Okay? Why again? Because these parties undertake to pay only if the instrument has been dishonored. So a demand should be first made on the party primarily liable through presentment for payment in order to charge the party secondarily liable with liability. Okay? Now that's the general rule. Let's go to the exceptions. Okay? There are instances when presentment for payment is not necessary to charge the party secondarily liable, meaning that they will be liable on the instrument right away. Okay? Now, first, no, as to the drawer only. The drawer does not have to be given presentment for payment, no, if he has no right to expect or require that the drawee or acceptor will pay the instrument. Okay? That's the first exception. Let's give some examples, no? For instance, the drawer has no funds at all with the drawee. Then he has no right to expect that the drawee will pay. Okay? Or if the drawer has withdrawn all his funds, or the drawer and the drawee are the same person, in those instances, the drawer has no right to expect or require that the drawee or acceptor will pay the instrument. In this case, all other secondary parties are discharged. Okay? Next exception under Section 80, which refers to an endorser for whose accommodation an instrument was made or accepted. Okay? So, presentment for payment is not necessary to charge that endorser. Okay? Because where the instrument was made or accepted for his accommodation, and he has no reason to expect that the instrument will be paid if presented. Okay? So, representment must still be made to hold ordinary endorsers liable. This exception applies only in case of accommodation. Okay? If there is no presentment as a general rule for the ordinary endorsers, then they are discharged. Okay? If there is no presentment to the party primarily liable in case of ordinary endorsers, then they will be discharged. Okay? Third exception, no? Presentment for payment is not necessary when it may be excused or dispensed with under Section 82 of the Negotiable Instruments Law. Okay, and what are these? No, first, where after the exercise of reasonable diligence, presentment cannot be made. Okay, so this requires an active search. Okay, he has to make inquiries. No, so second, no. Presentment for payment is excused or dispensed with where the drawee is a fictitious person. You cannot expect presentment for payment to a fictitious person. Third, by waiver of presentment, whether express or implied waiver. Fourth, finally, where the bill has been dishonored by non-acceptance. Okay, because if it has been dishonored by non-acceptance, you cannot expect that they will pay something that they did not accept. Okay, so presentment for payment is excused in those cases. Okay, now take note, do not confuse this instances when presentment for payment are excused from the excuse of delay. Okay, because delay in making presentment for payment may be excused in certain instances. Okay, so specifically, when the delay in presentment for payment is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence, then the delay in making presentment for payment is excused. But if the cause of delay ceases to operate, presentment must be made with reasonable diligence. In other words, the delay is excused, but you still have to make presentment for payment. Unlike in the instances I talked about earlier, a presentment for payment is totally excused, and the party secondarily liable will now be liable already on the note. Okay, notice of this presentment for payment will be excused. Okay, and okay. So, correlate this rule on delay with section 147, no? Which also excuses delay in presentment for payment on the day it falls due when the time is insufficient to present the instrument for acceptance. Why? Because the places for acceptance and payment are different. So, let's say, you know, to make it clear, no? So, let's say there's an instrument which is due on October 10. But the party only received it, or it was delivered only to the party on October 9. So, of course, on October 9, he presents it. Let's say in the afternoon, he presents it for acceptance. Okay? But the acceptance was presented in, the presentment for acceptance was done in Zamboanga. Okay? But under the terms of the instrument, it is payable in BPI Manila. Okay? You can't you will not be able to reach the BPI Manila in time to make presentment for payment. Okay, so in this case, delay is excused, no, in presentment for payment, provided reasonable diligence is exercised, and the delay in presentment for payment will not discharge the party secondarily liable. Okay, now take note also, no, that presentment for payment, in order to be sufficient, must be done at the proper place. Okay, so the rules under section 73 are as follows, no. If there is no place for payment that is specified, when there is a place for payment that is specified, then of course there, no, because it's specified. But if there is no place that is specified and there is an address of the person that is stated, the address of the person to make payment is stated on the instrument, then present it at that stated address. Okay, but what if there is no place for payment, there is no address given? Okay, then you make presentment for payment at the usual place of business or the residence of the person who is bound to make payment. And in any other case, wherever the person to make payment can be found, okay, where he may be found, or his last known place of business or residence. Okay, take note of section 70 that if the instrument by its terms is payable at a special place and the payer is able and willing to pay it there at maturity, then such ability and willingness are equivalent to a tender of payment on his part. Okay, now let's go to exhibition, no? Because again, presentment for payment, in order to be sufficient, the instrument must be exhibited, after which, if it will be paid, the instrument will also be surrendered. Okay, now the instrument must be exhibited, okay, to the person from whom payment is demanded, and when it is paid, it must be delivered up to the party paying it, meaning you surrender it to him. And what is the purpose of this exhibition? First, no, it's to enable the debtor to determine the genuineness of the instrument. He will see if it's genuine. Okay, and also to determine the right of the holder to receive payment. Ikaw ba talaga ang tatanggap ng kabayaran? Okay, and finally, to enable the payer to reclaim possession of the instrument upon his paying the amount. due thereon. Okay? Again, it has to be face-to-face because if it's on the phone, you can't exhibit it, no? And you cannot surrender it. Okay? So, exhibition will be excused in case the payer does not demand to see the instrument and he refuses to pay it on some other ground. Okay, also when the instrument is lost or destroyed, or if it's unnecessary because the payer either failed to object to it, he waives exhibition, or when he admits already the authenticity of the instrument and simply pays upon seeing it, no? Now, finally, let's have some special rules, no? In case the instrument is payable at a bank, then it must be presented for payment during banking hours unless the payer has no funds at all in the bank, in which case you can make presentment for payment at any hour before the bank closes. Okay? What if the payer is dead, no? If the person liable is dead and there is no place for presentment specified, then presentment for payment should be done to his personal representative if he can be found. Okay? And in case of partners, presentment for payment may be done to any of them even if the firm has been dissolved. And finally, in case of joint debtors and there is no place of presentment specified, presentment for payment must be done to all of them. Okay? So now, what if payment is refused or cannot be obtained? Okay? So if payment is refused or cannot be obtained after presentment of payment, or in case presentment is excused and the instrument is overdue and unpaid, okay? The instrument is now to be considered as dishonored by non-payment. It's different from dishonored by non-acceptance. We talked about that last episode, no? Now, it's dishonored by non-payment. Okay? And the effect is there is an immediate right of recourse to all parties secondarily liable. It now accrues to the holder. Okay? The holder now has a right of recourse. He can now go against all those parties secondarily liable, provided, of course, he gives them a notice of dishonor. Unless, of course, the notice of dishonor, the giving thereof is excused. No? Now, remember that the object of the notice of dishonor is to inform secondary parties that the primary parties failed to satisfy their obligation to pay, and to advise the secondary parties that they will now be required to make payment. Okay, this is just a review because I already talked about notice of dishonor in depth in my last episode. I'll just be giving you some reminders, okay? Any party to whom notice of dishonor is not given is discharged and cannot be held liable on the instrument, subject, of course, to the exceptions provided for in the law, okay? So now, notice of dishonor must now be given to the parties secondarily liable, and after such notice is given, the holder can now enforce the instrument against them and get paid. Okay, except of course, when the giving of the notice of dishonor is excused or may be dispensed with. Okay? I talked about this last episode. Let's just review. I'll give you a brief summary, no? And the notice of dishonor is excused or may be dispensed with, meaning that the secondary parties may now be held liable even without the notice of dishonor in the following cases. Under Section 109, when the giving of notice of dishonor is waived, expressly or impliedly. Okay? Second, under Section 112, no? When after the exercise of reasonable diligence, notice of dishonor cannot be given or does not reach the party sought to be charged, okay? Next, under Section 114, notice of dishonor is not required to be given to the drawer. Take note, to the drawer. If the drawer and the drawee are the same person, the drawee is fictitious or doesn't have capacity to contract. Third, when the drawer is the person to whom the instrument is presented for payment. And fourth, where the drawer has no right to expect or require that the drawee or acceptor will honor or pay the instrument. Okay? Another instance when the notice of dishonor, the giving of the notice of dishonor is excused, is when the party to be notified knows about the dishonor. Okay, this is under Section 115 or 115, no? So, there are instances when the notice is not required to be given to the endorser, okay? So, again, these are when the drawee is a fictitious person or he doesn't have capacity to contract and the endorser was aware of that fact, no? Second, when the endorser is the person to whom the instrument is presented for payment. And third, where the instrument was made or accepted for the accommodation of such endorser. Okay? Finally, in case the holder fails to give notice of dishonor and the instrument is now in the hands of a subsequent holder in due course with no notice of the failure to give notice of dishonor, his rights are not prejudiced by such failure. I talked about this in the last episode. Take note, however, that there is an additional ground in case of bills of exchange under Section 116, no? When this notice of dishonor may be dispensed with, and that is when notice of dishonor by non-acceptance has already been given, then notice of subsequent dishonor by non-payment is no longer necessary. Okay? Because you already gave, you tried to present it for acceptance, then it was refused. There is no more need to present it for payment because you will no longer expect that he will pay it because he did not accept it anymore. Okay, so you just have to give notice of dishonor for non-acceptance to the party secondarily liable. Okay, you no longer have to give notice of dishonor for non-payment again. So hindi na kailangan dalawa. But take note of this, no? Under Section 151 muna, no? When a bill is dishonored by non-acceptance, an immediate right of recourse against the drawer and endorsers, meaning the party secondarily liable, okay? An immediate right of recourse against those parties accrues to the holder and no presentment for payment is necessary. That is the basis for the rule that I mentioned just a while ago, no? Okay? So again, if a bill is presented for acceptance and it is refused, then the holder must give notice of dishonor to the party secondarily liable in order to charge them with liability. If he presents it again for payment to the drawee, let's say, he does not need to give a secondary notice of dishonor again, no, to the party secondarily liable because it's useless. Okay? But, no, take note, if the holder presents the instrument for acceptance and it is refused, then he wanted to try again, second chance. Let's present it again for acceptance. And then it is accepted. Okay? If it is accepted, then he presents it for payment and then payment is refused, he must now give a notice of dishonor for non-payment even if he may have given a previous notice of dishonor for non-acceptance. Okay, that is the exception, no? Because in the subsequent acceptance, no, of the instrument which was initially refused, no, creates a new relationship among the parties, no? So to summarize it all, no, if the instrument is a promissory note, it's easy. No need to worry about the rules on presentment for acceptance. Just go straight to presentment for payment, and it should be done within a reasonable time if it is payable on demand, or it should be done on maturity if it is payable at a fixed or determinable future time. Okay? And if presentment for payment is refused, then you just have to treat it as dishonored and give notice of dishonor to the party secondarily liable. Okay, in order to charge them with liability. In case of a bill of exchange, the holder must first present the instrument for acceptance. Okay, he should present it for acceptance, and then if it is accepted, then we now go to presentment for payment. Okay, which must be done within a reasonable time from the last negotiation and of course before it is overdue. Now, if the acceptance is refused, then of course he has to give notice of dishonor for non-acceptance to the drawer or endorsers to hold them liable. But if the instrument is accepted, then he must present it for payment, and if payment is refused, notice of dishonor must now be given to the secondary parties to hold them liable. Okay? In both cases, whether it be a promissory note or a bill of exchange, okay, if the presentment for payment is accepted, no, or it is paid, then the instrument and the secondary parties, as a general rule, will be discharged. The instrument and secondary parties will be discharged as a general rule. Okay? As to discharge of the instrument, we'll talk about that in the next or a future video. Okay? So I hope you may have picked up a thing or two, and that's it for the rules on acceptance, presentment for payment, and dishonor for non-payment. I hope to see you soon, and please continue supporting this channel. Okay? Thank you. Bye.